Ladies and gentlemen, I welcome all to my channel. Recently, the Madras High Court Division Bench has pronounced an important judgment in which the Madras High Court Division Bench, comprising Justice R. Subramaniam J. and Justice R. Saktivel, has pronounced an important judgment in which they have mentioned that without producing the sale deed or without producing the parent document, they have permitted the petitioner to register uh, a document. As far as as far as Tamil Nadu is concerned, in practice, every person who wanted to register a document has to produce the previous documents, the original of the previous document, original previous document. Without producing the original document, they cannot register a document. That is a situation prevailing in Tamil Nadu. So that in the instant case, the judge has permitted the past order and set aside the order of the sub-registrar who refused to register a document because of the non-production of the previous original document, and allowed the petition and directed the sub-registrar to register the document without insisting the production of the previous document. Let us see the judgment and its impacts and how far it can be useful to to the public in general. How far we can utilize the judgment for registering our document without the production of the previous document. All these aspects let us see in this video. So this is a judgment produced by Madras High Court. It was passed in writ appeal number 1160 of 2024. The judgment was pronounced by the Honorable Justice R. Subramaniam J. and Honorable Justice R. Saktivel in a case filed by R. P. Papu versus Sub-Registrar Rasipuram. This is a case, and judgment was pronounced on 27/9/2024, and it was also published in the newspaper on 21st October 2024. So let us see first of all, let us see the facts of the case. The facts of the case is that the petitioner's father got a property through a partition deed. Then the petitioner wanted to, being the legal heir of the one of the legal heir, wanted to release her interest in the property in favor of his brother. Unfortunately, the previous deed, namely the partition deed through which their father got the property, was not available. So when they approached the respondent, namely the sub-registrar Rasipuram, the sub-registrar refused to register the sale deed since the original partition deed in which the property was allotted to the father of the petitioner was not produced. So as against since the registrar refused to register the document and also issued a refusal order. As against the refusal order, they filed a writ petition before the High Court, and the High Court also dismissed the petition on the ground that they are not entitled to register the deed without the production of the previous original document as required under Rule 55A of the Tamil Nadu registration rules. Now they preferred an appeal. In the appeal, the Honorable Justice comprising R. Subramaniam J. and R. Saktivel J. allowed the petition and set aside the refusal order issued by the sub-registrar and directed the sub-registrar to register the document without the production of the previous document. As far as the Tamil Nadu is concerned, there is a notification published in the Gazette, Tamil Nadu Gazette, that is the date of publication is 2020. This was a notification by the government, Commercial Taxes and Registration Department, amendment to the registration rules under the Tamil Registration Act 1908. This was published in September 5th September 2022. So in this rule 55A, the amended rule 55A was inserted to the Tamil Nadu registration rules, in which section 55A and there are three provisions were added to the registration rules. So section 55, rule 55A stipulates that the production, whenever the person wanted to register a document, he has to produce the previous original date by which the executant acquired the right. So supposing a person wanted to register a document, he should produce the document, previous document through which he has acquired property rights over the particular property. So this rule says that unless it is produced, unless the executant produced the previous original document, such type of deed shall not be registered. Like what Rule 55A says. There are three provisions. One of the provisions says that whenever the original deed is not available, in such cases the document cannot be registered unless the presentant produces a revenue record evidencing the executant's right over the property, such as patta issued by the revenue department or tax receipt. So another provision is also that whenever the document is lost, then when the executant has to produce the non-traceable certificate from the issued by the police department, along with an advertisement published in the local newspaper as to the notice of loss of previous original document. So these two provisions, one provision is it speaks about whenever the original deed is not available. First case, it speaks about the situation where the document is not available. The second case provision speaks about the document is available but it is lost. There is a difference between the two. In the first case, supposing the property belongs to ancestors' property and they did not have any original document, they only have some that was acquired by inheritance. They do not have any ancestral property. They do not have any document. In such cases, the provision stipulates that they have to produce patta or tax receipt in the name of the executant. The second provision says speaks about the situation where the document is lost. When the document is lost, the executant who comes to the register office has to produce a non-traceable certificate from the concerned police station and also produce the paper publication advertisement published in the newspaper about the loss of the document. So these are the Rule 55A stipulates these conditions. As far as this case is concerned, in the case the original partition deed in which the property allotted to the father was not available, and the executant produced a certificate copy from the concerned registrar of the partition deed. The certificate copy of the partition deed was produced before this registrar, and the sister wanted to release her share in favor of her brother. So the judge, as far as the judgment is concerned, the judge has clearly mentioned that the Rule 55A stipulating the production of the non-traceable certificate and paper publication is not required for this instant case, and he directed the sub-registrar. He set aside the order of the sub-registrar and directed the sub-registrar to register the document. If you go through the entire judgment, the entire rule, so 55A was not held invalid or unconstitutional. They have not struck down the rule. They have only set aside the order of the sub-registrar and directed the sub-registrar to register the document. So as per in the judgment, the judge has given various reasons. The reasons are that as far as the property transaction is concerned, the principle of caveat emptor alone applies. Therefore, every purchaser or every person who is going to acquire the property alone has to take care about the genuineness of the transaction, genuineness title of the transferor. And as far as genuineness is concerned, with respect to this transaction, the registrar can check up the genuineness by go through their own certificates, own documents on the certificate copies which was already issued by this same registrar office, and so they need not insist for the production of the original need to check the genuineness, like what the judge has observed. Furthermore, the judge has also observed that in getting a non-traceable certificate is a very difficult job, and with the parties has to bear a reasonable cost. The judge has observed that there will be the party has to pay a big price to obtain a non-traceable certificate from the police, and there are instances where the parties are approaching other states to get the non-traceable certificate. So the insistence of such type of non-traceable certificate will only cause serious damages to the parties. So the insistence of such type of non-traceable certificate is not required for this instant case, and so he set aside, the judge has set aside the order and directed the sub-registrar to register the document. So now, if you go through the entire judgment, the judges has not struck down or has struck down the rule. They have not, in my opinion, they have not observed that this rule is totally invalid and totally unconstitutional. They have only set aside the order of the sub-registrar and permitted and directed them to register the document to the instant case. So if you go and approach sub-registrar to register any document without any production of the document, and if you produce this judgment, in my opinion, they may not come forward to register the document simply based on this judgment, because in my opinion, this judgment will apply only to this particular case, since the judge has not declared or set aside, cancelled the entire rule. So, if you approach the sub-registrar, they may not register your document without production of the original previous document. And if they refuse to produce a document, you can approach them, you can show this document, or if they refuse, you can approach the district registrar or IG registration to give a direction to sub-registrar to register the document on the basis of the principles incorporated in this judgment. If they insist, and if you are not able to get the proper directions, if you are not able to convince the sub-registrar, or if you are not able to get a proper direction from the district registrar or IG registration, you may also approach the High Court on the basis of this, on the basis of the facts mentioned in this case. So you can, if you want to register any document, you can apply a sub-registrar and you can ask the sub-registrar to pass a refusal order. Then after obtaining the refusal order, you can approach the High Court and you can show this judgment, and the basis of this judgment, you can get a similar orders to your case. So, and you can register your document on the basis of the proper order obtained from the High Court with respect to your case. This is my opinion. I am of the opinion that the judgment has not totally struck down the entire rule, and it has not permitted all to register document without production of the previous document. In my opinion, this document will be applicable only to this instant case. If you want to follow the same, you can also file a proper writ petition and get appropriate order for your case. This is my view. Let us see what happen in future, because as far as the judge has referred to 3 other judgments and followed the same, and the government has quoted that all those judgments were appealed, and the appeal is pending in the Supreme Court. So you have to see the verdict of the Supreme Court with respect to this point. If the court specifically struck down or declared the rule unconstitutional, then the entire rule will go out and you can register directly without production of the previous document. And as far as this judgment is concerned, the judge has struck down only the registrar's order and not the rule entirely. So this is my view and this is my opinion. Let us see what happened in future. So ladies and gentlemen, you may watch my channels, YouTube channels. There are two channels. One is in Tamil. It's called Razyak Sattam Arivom. Razyak Law Tube is an English channel. In addition to that, you may also watch my website, Google site, views.ali Associates Chennai. There are a lot of videos, lot of playlists through which you can click any one of the relevant videos and you can clarify your doubts. Whenever you have any doubts through my videos in the YouTube channels or in my websites, you can watch the videos and you can clear all your doubts. In addition to that, if you have any specific doubts, you may also contact me to the cell number. If time so permits, I will try to give you proper consultation or advice as may be required, provided I have time and on prior appointment. I will come again with another topic. Until then, goodbye. Razyak Ali.